Hi, everyone. Wow, thanks for coming. Such nice audience to talk about data. My name is Omri Ben-Shahar. I see many students that I know and recognize, but not in the usual seats. So but it's nice to see you here. So last week I sent a manuscript to a publisher, finished writing a book. I first want to give a shout to Paul Agbaggio, who's sitting there at the corner very modestly, who held my hand and worked with me very closely on this book. Thank you, Paul. This is an attempt to change the way we all think about data protection. And I call it Why Fear Data, with or without question mark. Both reasons to fear, but not the reasons that we always think are the right ones. I think that they are not the right ones. And why not fear data? And against some of the data protection laws that we're seeing. I'm going to talk for about half an hour, maybe a little bit more, depending how much I get carried away with. I feel pretty passionately about these issues, so stop me if it becomes too much. And then we'll have time for questions, because I'm confident audiences that around the world that I've presented these ideas to were pretty wild, pretty passionate about their responses, sometimes very hostile. So let's see. This is Chicago, so you probably just nod in acceptance. What's the big deal? I have a thesis in this book, and it has three parts. First, try to argue, to describe data protection as obsessed or as focused on one major interest, and that is data privacy. It is widely discussed. There's a whole aisle in the library upstairs, outside my office, on data privacy protection. And this is the primary protection, data privacy is the primary goal of data protection law. There are notions of, it works through a basic principle of a fundamental right to data privacy. It exists in European law. There is a notion of data self-determination. It's part of controlling who you are, like controlling your body and your property and your other personal issues. So is your data. There are principles of data minimization, namely how much the data can be taken and processed when you participate in the digital economy and so forth. So that's the canon against which the book is written. I'll just mention that the entire data privacy literature is within that canon. Variations on how to expand it, I want to put a stop on that. I want to suggest that there is a different path that we can backtrack, go to the fork in the road, and go the other way. Not without protection. In fact, I'm proposing more significant protection, but of a different kind. I'm asking in the book, what is the cost of data privacy? And this is something I'll focus on here, that we are focusing on private harms and protecting individuals rather than focusing on environments, on communities at large, protecting the integrity of communities. And in the course of doing that, of ignoring social aspects, public goods, we are also ignoring the great benefits, social benefits of data. And lastly, I will propose a concept that is foreign to data protection law. I call it data pollution, which I think gives us a roadmap on how to address the big things that bother us and we worry about in the age of big data and AI. Okay, so let's go into this. I'll skip the first part, the data privacy canon. Others, I'll just, I want to come clean. I'm an outsider to data privacy law. I don't teach privacy. I'm not an expert on it. I come to it from consumer protection law. That is one of my main fields. And I'm not that young, but I remember that when I started in that field, all the interest in the field was a protection of vulnerable people, borrowers, poor people, poor borrowers, people that are stuck in catastrophic transactions, take loans that they cannot repay, and things like this. This was what consumer protection was about. Gradually, roll the time forward to today, all of consumer protection is interested in, the darling of the intelligentsia, data privacy. It is people that don't use Google, use DuckDuckGo, are the kind of the major players in the academic and regulatory area of this field. And I come to it from consumer protection to suggest we've lost our compass. Okay, but I'm not going to talk about data privacy law. There's an excellent course in the law school by Professor Strahilovitz. Instead, I want to talk about how the social cost of privacy laws, and these are some things that I've discovered in writing the book, and part of the book is are these case studies. I want to talk about three major data technologies that are at the core of privacy concerns: tracking how you drive, facial recognition software, and medical privacy. So these are areas where privacy concerns are significant. I'm not against privacy protection in these areas, but I want to show you something that you haven't seen before. So first, I'm tracking how people drive. So there is this technology where people that drive the cars have these embedded devices that record how people drive. You don't have it, and you don't turn it on unless you want to, and it is offered by auto insurance companies, and it tracks speeding, miles driven, sharp turns, sharp brakes, texting while driving, things that we know are not just correlated with accidents, like male-female demographic classifications, but cause accidents. And based on the data that comes in real time all the time from drivers, from the cars, the insurance company can make a prediction of how likely are you, as opposed to somebody else, to get into an accident. And then based on this safety score, they will calculate the premium, and people with higher safety score will pay less. And the premiums will change as people's safety scores change. If it goes up or down, the monthly premium changes. That's how it works, and enrollment is entirely optional. It's not some kind of thoughtless click, I agree, and before you know it, you're enrolled. It involves turning on, downloading an app, and all of that stuff. Oh, we'll see why I'm talking about this. This is very heavily regulated by data privacy, but that's what it will look like on your app, on your score. This is your safety score, and tells you that various factors that affect your score, like for how many times you got too close and got forward collision warnings, hard braking, and so forth. The main benefit of it, there are two main benefits. One has to do with safety. It causes people to drive safer. Why? Well, in theory, there's an economic reason. You're rewarded by a lower premium. You're also being told how to drive better. You know, driving is where originally social psychologists found that pattern where 90% of the people think that they are better than the average. It's true about almost every human activity, but it originates from driving. It was shown endless times that everybody thinks, you know the joke, how if someone drives faster than you, then they are maniacs, and those that drive slower than you are stupid. But you are always right. So people don't know how the 90-50 is there, even after people get into accidents, even for habitual, people that get often into accidents, even if people who get into accidents that were adjudged their fault, 90-50. 90% continue to think that they're better. People don't know. This shows you what you're doing. So there is a coaching element. And there is a sense, a psychological sense. There's a big brother somewhere. There's a big eye in the car that looks at you. And something that is otherwise impulsive and thoughtless becomes more kind of deliberate. That's in theory. In practice, the effect is phenomenal. It has been studied based on data and in experiments, in broad studies that have all confirmed a number roughly in the 30% reduction of fatal accidents. Can you imagine that? Nothing in the history of automotive or highways comes close to this effect. Not seatbelts, not airbags, not maybe just road bumps, those that slow you to 5 miles an hour. But since we're not going to use them on highways, we have a technology here that costs nothing. You don't have to build guardrails or something. It's just data. It changes how people behave. And there is, I'm giving some examples of where the data comes from. These are studies that show how people change after they enroll, what happens to people that enroll as opposed to those that did not enroll, and it all comes from large data sets and consistent with the 30% safety effect on fatal collision. Why am I telling you all that? Because, oh, wait a minute. I'll tell you why I'm telling you in just a second, but there's another big benefit. The other big benefit is fairness. First of all, everybody pays lower premium because there are less accidents. But it particularly affects people who would otherwise be classified under the regular demographic classification as dangerous. Now, if you have you ever bought auto insurance, you know what kind of information they want to know about you. But it turns out that people with big incomes, big houses, and big resumes pay less. Not exactly a progressive pricing scheme. Now you have a different image. It doesn't matter who you are. We don't need to know whether men, women, all sorts of other features that might be problematic on grounds of either equal protection or distributive justice are ignored. We just look at things that cause accidents, and everybody gets the same chance to qualify for high scores. And so the most controversial element, for example, credit score. You know that auto insurers use your credit score to price you. Credit scores have nothing to do with driving, but it so turns out that they're correlated with the likelihood of accident. It's so unfair. Who has low FICO scores? Poor people, members of marginalized communities, of racial minorities. They a priori score poorly, and indeed they pay roughly, all else equal, 75% more than people than those who are more fortunate. So we don't have to rely on that. And this is not a small program. This is not something that happens to some people sometimes. Everybody drives. Everybody drives, pays car insurance, and it's a lot of money for an average household income. And you have this corrective device that eliminates the unfairness. And it's all personalized. It truly doesn't matter to which group demographically you belong. So all of this, here's price me how you drive, not by how you think I am, who you think I am. All of this is great news. The problem is that California prohibits it. You can't do it in California. Why? Because, as the insurance commissioner said, we won't bend on protecting consumer data and privacy. And here's another caricature of law. New York State, it permits the tracking, but only to reduce your premium, not to increase. On consumer protection grounds, New York says, you cannot increase people's premiums by this data. What exactly is the consumer protection ground that allows people who run red lights and put others in danger to stick with their low premiums? Not entirely clear. What is particularly sad, is that New York prohibits using texting while driving data, which of course you have because many of these devices are in the app, in their phone. They know if you text while you drive. They don't allow insurers to use that data to reduce the safety score. Of all things, why is New York so sensitive, so ticklish about texting while driving? It's something that is prohibited. New York knows that it is the #1 cause for urban accidents. New York knows that it is a very dangerous thing, but it does not allow it to be included in safety scores. Why not? Because it comes from a personal device. Texting is your phone. Your phone is your private, is your protected environment under privacy law. There is heightened protection. So you cannot do that. California has 4,000 annual fatalities. And 30% reduction will be 1,200 lives. The technology has existed for over 20 years. It's 25,000 lives that could be saved if California were to, instead of prohibit this, mandate it. Now, I get that mandating is an intervention that we might be a little uncomfortable about, although we do mandate auto insurance, but it is, at least make it optional. So many lives could be saved. So that's example number one. Example number two is facial recognition. And here I'm truly entering the sanctum sanctorum of data privacy law, of privacy protection, recognizing people by their face, and not just entering your phone. You're in a protest. You are doing something and you can see who you are. Why do people wear masks now in protests? Because of facial recognition technology. It's truly a scary technology in terms of the use by authoritative powers and things like this. We know how it is done. There are a lot of descriptions on how it is now done in China with street cameras and that follow people and rate them in many different ways. So guardrails are truly important, what it can be used for. But they must be done also with the thought not only of the potential harms, that one day we're going to be like China and we have to worry about it and protect against it, but the benefits of the technology, so that we won't do what we're currently doing, which is banning it. So many jurisdictions ban it. And what is the benefit that I want to focus on? It is a benefit in law enforcement, okay, but not in the law enforcement kind of thing that would be controversial, namely, illegal political protests or pickpocketing. It is against the most dangerous and, serious crimes. I'm talking here about sex and human trafficking. People who are taken away from their homes, from their countries, hidden somewhere to become slaves of some kind and never see the daylight. It is the fastest growing criminality. It's the hardest to enforce against because they disappear, because they come from weak and poor and migrant communities. And it's hard to solve. But there are opportunities to identify them when they are passed through ports, or when pictures are posted, sleazy pictures are posted on the dark web of sexual encounters with with one of the victims, and it can be used by law enforcement for that purpose. It not only can be used, it has been used with great success, like unbelievable success. So here's 21 state attorney generals, including from many very, very blue states, warned Congress against passing laws against this or doing a hearing. They said that, here, look at the number. 18,000 victims this was early in the days of the technology, were already rescued. There's various tools that have been developed and used in law enforcement. In 40,000 cases, released 9,000 children. The stories, there are anecdotes that mind-blowing. I've spent weeks, if not months, reading about the stories that you hear, that you don't hear that much about the success of the technology in solving this crime. And the ability to use it in such profound ways. I just gave here a few bullets. My book includes various cases in which technologies were offered, for example, by Apple, to be able to find, to predict, or not predict, to identify sex trafficking or sexual assault cases in people's photo library. Apple withdrew that. You don't want Apple to scan your photo library. But if the risk of false positive, that they might mistakenly think that you're a trafficker, is almost zero, and the ability to identify and save victims is very high based on very good AI technology, well, at least it should be on the table. It has to be discussed. It cannot just eliminate from the table, from the discussion, the benefits of the technology. Unfortunately, it is entirely eliminated. There's not a single academic article or regulatory white paper talking about that. Everything talks, the entire literature, books have been written against this without mentioning, even in a wink, these kinds of benefits. It's a taboo. Why? Because data privacy is sacred. It's a fundamental human right that's as religious as it gets in law. Now, there is, so here, the EU AI Act bans it as the most dangerous technology. It has, to be accurate, it allows for an exception for serious crimes. But that exception must be granted by a judge per individual case with a privacy statement, one by one. You can't do this broad nets, looking at the dark web, scanning photos, and matching them with photos of missing person, because that's not allowed under the EU Act. Privacy watchdogs keep saying, you cannot exchange freedom and privacy because of some early anecdotal evidence, as they call it, that it might help some people. This is wholly insufficient vis-a-vis civil liberties. I'll just say, I don't know what's the right balance. I just know that we need a scale. We don't have just reasons to fear the technology, we also have reasons to embrace it. There are various local bans in many cities and states in the US against it. The government of New Jersey prohibited the use of the technology. Day after, he celebrated arrests that were made by as a result of using the technology. So there's a lot of these paradoxes. Here's what the EU data privacy czar says. Given the nature of the personal data at stake, sensitive biometric data, and that vulnerable people may be involved, migrants, those are the victims, a vulnerable victim, more attention must be paid to the impact on the fundamental right to privacy and data protection. Those migrants that you're trying to rescue, he says, they have privacy rights. So don't use so quickly that technology to rescue them. Doesn't that sound crazy? To me, it does. Now, part of the reason facial recognition technology has such bad rap is that in the early days, there were cases, I've read about 6 cases, in which young black men were arrested because of erroneous identification. There was a picture or photo taken from a burglary or something from a street camera or from CCTV, and they ran it through the software, and the software spat out a name, and they went and arrested that person in front of their family and took them to jail and, released after a day or the same day or maybe a few days. Super tragic and upsetting stories. They are led to the entire field of data privacy calling facial recognition technology a racist technology. Now, what's really going on? Why were the mistakes done that way? The reason is what is known as the other race effect. This is done, it's not just about technology. Most humans, in most contexts, when surveyed, are finding it easier to identify and distinguish individuals of the same race. It's true in China, where they've shown that the same race effect makes it harder for Chinese, Asian people in China to identify Caucasians, and vice versa. The algorithm also has the problem for the same reason. It is shown less images of members of racial minorities. And because of data privacy laws, oftentimes the training data cannot be tagged by race. So the race information, the cross-race images are mixed into in the end, it makes it more difficult to identify the race of racial minorities as opposed to the majorities, and it takes time for the algorithm to figure that out. Largely, that problem has been solved because this was a problem at the infanthood of the technology. And in a book by Kashmir Hill, who is the New York Times privacy and technology reporter, book that is called Your Face Belongs to Us, and it is a scathing critique of the racist technology. Not a page in the book is devoted, by the way, to the benefits that I've described in human trafficking. But at the end of the book, Kashmir Hill quotes an activist who says that the window of time for the racial disparity criticism to be effective is closing, as top developers have focused on addressing the problem of biased algorithms. And she said that privacy advocates worry that greater accuracy across diverse groups would be used as a justification to deploy the technology more widely. So what's exactly going on here? Why write a book about racist technology and describe one by one the different cases, the tragic cases of erroneous identification and arrests, if the problem is the window for this critique is closing? Why not ask, for example, what is the rate of false positive of this technology compared to police not using this technology? What? Police doesn't, there are no false arrests of young black men? It seems mind-blowing to me that the question, what is the option, what is the downside, what is the upside, what are the alternatives, never comes up. And so that's my second case study. The last one, I don't have time and I don't want to monopolize the entire discussion, has to do with another core privacy area, which is medical privacy. Here, the main problem is that medical records have shifted over the last generation from paper to digital. And the question is, now it's easier to share, to copy, so we have new laws like HIPAA, IRBs that supervise medical research, medical progress, are also very strict about how the information is collected and stored, and there are privacy culture in healthcare. Anybody who has ever had something to do with that recognizes that it is a very stiff environment in terms of medical privacy. Doctors can't call you on the phone. They have to communicate through secure channels. Think about how much legal medical advice cannot be given in a way that would be useful for people because of that. The information that, the studies that have looked at that, and social scientists do look at that, have shown that how many lives could have been saved if states had allowed the transition to electronic health records faster. Some states allowed, others had laws that prohibited that. In a study by one of my heroes, Catherine Tucker at MIT, who studies the effect of various data privacy protections in economic methods, they have suggested that the record could have saved 6,400 lives of infants per year if there was a complete national transition to electronic health records, and particularly so for black babies, whose rate of mortality is 3 times as high, largely because there are less records that are available in the same hospital, in the familiar doctor, exactly the things that electronic health records would solve cannot be solved. This is something, by the way, I see throughout every area, that medical privacy protection, when it has social costs, it is targeted more on members of underprivileged groups, poor people, urban racial minorities, old people, sick people, uneducated. Those are where the losses are more concentrated. So I'll skip that. I'll just say this is, why part of a major part of my book is devoted to this question: privacy protection, at what cost? Can't do the privacy protection without asking it, but we're constantly doing that. And now we'll have maybe 5 minutes to talk about what do I propose instead. So if privacy protection is the main tool, the main guiding light for data protection law, and I think that it should not be, what would I replace it with? So I would think of it as a problem of data pollution, not data privacy. Trying to shift your focus from individual harms to the inside of you, to something that we all share together, environments. That's what pollution does. It harms environments. So for that, we have to think about the harms as public, not private harms. What are those harms? So think about this kind of the moment in which data privacy became a thing. 2016 election, Cambridge Analytica sending personalized fake ads to 87 million people to try to affect how they vote, Brexit, Trump, whatever. This seemed to be something that everybody agreed was not good to send, no matter what political side you were on, fake information that is personalized and tailored to people's vulnerabilities or whatever it is not good. And indeed, this was widely described as a privacy protection. FTC fined Facebook $5 billion for privacy violation, endless privacy hearings, and so on and so forth. But the harms were not private. None of the targeted people who voted for whatever they voted, Trump, Brexit, some other things that Cambridge Analytica did, do not feel that they are harmed. If you knock on their door and say, we're coming to help you, they'll kick you out. The harm was to an election system, to democracy. The harm is polarization. The harm is misinformed voters. There is nothing more public than the civic environment that we live in. Or turn your attention to another canonical moment in data privacy. This is 2018. This is the Strava social network for athletes. I see some well-fit people here nodding there in recognition. I didn't know about its existence, but I saw that. This was my, by the way, aha moment. That's where I figured out one day I'm going to write a book on this, because they're not understanding the problem correctly. Strava allows people that jog and run and do all sorts of activities to post their map of from where they went to where they went and how fast for their friends to see. And it also has, you see the picture, heat maps where a lot of people are actually. So Chicago's Lakeshore Trail has very, big concentration of big light. So you see, this is for an example of what Strava showed outside Kabul in Afghanistan. Why is there like a big concentration outside the city? This is Kabul. There's no athletic retreat that people come to from all over the world. It's American GIs, servicemen, CIA operatives stay there, and they run at a much greater incidence, as you see, than Afghans. And so that became, Strava is exposing our location. The same place in Niger, in Somalia, in other places all over the world. The political scene was very upset. It was front page news. And look at how it was framed, a senseless assault on our privacy, a privacy nightmare, giving away tons of privacy. Privacy? That's the last thing these joggers and cyclers wanted. They want to show what they're doing. The harms are national security, putting others at risk. It's pollution. You're polluting the environment. You're making something unsafe. When the Strava CEO was paraded before Congress, he assured everyone, don't worry, we already fixed the problems. We made it easier to change the privacy settings. But that's not how you solve problems of pollution. And the last example is data spills. How many times have you gotten notices that your data was breached by some website or some processor that you visited before? Now, that sounds to you like private harm, right? Because you will be subject to identity theft. But no, you are insured against that. Banks cannot charge you the cost of fraudulent charges. It's under federal law. That's called the Card Act. The same very similar for debit cards. Your home insurance, by the way, if you are a homeowner, does have also protection against that. But what happens here is that there is a harm. A lot of stuff is stolen, and the banks have to pay more. They cover these charges or whatever it is. It's not the individuals. The individuals have to change their setting. They have a new card. If it's a full-blown identity theft, there might be much greater hassle. A colleague just had this happen to them, and they said to me, you see this, I don't believe your play, you see, because I had to ask them, what did it take you? Said about 2 days of my time. Well, maybe for a law professor that's worth a lot. By the way, not my time, not worth that much, but the average, the FTC says, is somewhere between $1,000 and $1,500 cost per identity theft. Credit card fraud is much lower. So the private harm is small because it is insured. The private harm is great. So once again, we have this wedge between the harm to the individuals, what we call privacy, and the harm to society. And so my idea is to talk about it the way we talk usually. In the industrial era, we talked about industrial pollution and realized that giving people rights to sue is not enough. In the digital era, we'll talk about data pollution. And again, giving people individual rights is not the right to be forgotten. Have you ever exercised that? You heard about it, but we know people, I say never. A colleague corrected me and said, no, Google did receive 1 million requests over the last 12 years. Trillion searches and 1 million requests, not exactly blockbuster. But these private rights do nothing to address a problem of data pollution. So, and I try to show that legally, technically, the reasons they fail are exactly the reasons that they failed in the industrial era. In tort law, once, before environmental law was invented, pollution, how did the law address pollution? Well, you got to sue. You have a tort to sue in nuisance for your harm. But can you prove that your disease that occurred years after the exposure was due to that? There's a problem of causation. There's a problem of we have to await the realization of harm. There's a problem of evaluation. Tort law failed and environmental law was invented. Public law, public enforcement. The same exact same thing is happening now with data spill lawsuits, suits that mostly end with nothing. And so I'll just put in the roadmap for what I think we need. We need an environmental law for data protection. We can think about prohibitions and quotas, some data limits, and that we think about particular services that don't need particular data. Since data is not per se toxic, this is a very difficult solution to use. It's hard also in industrial pollution, but it's double hard here. We have something like data minimization laws. I already mentioned them previously. But it turns out that this is not really helping the social problems. Data minimization, say the websites, you can only collect and process data that is necessary for the functionality. You can't collect everything. Angry Birds, remember that game? You can't be, there were very curious birds as well, can't be, you shouldn't have information about all the contacts, or all the phone calls, all the texts of the player. So that's data minimization. The problem is that it hurts particularly small developers and small services because Google, Facebook, and the big ones have so many different services that they can combine it together. They do not, are not bothered by it. A data tax, so that's an idea that I'm analogous to carbon tax that I develop in the book. I think it has some purchase here. Just imagine, a penny per gigabyte or megabyte. Just tell those big processors of data, you have to pay a small amount. Make them think about it twice. Instead of the game that they're presently playing, data maximization, they'll start to think, what is the value of things like that? And then we can begin to work from the penny upwards when we think that there are reasons to tax more particular practices. It's all very basic idea right now, a platform to think further about how to address this. But it's not giving personal rights, cookie consents, to say, okay, I'm opting out. Liability for exposure. Hey, Equifax, you lost 140 million people's, all of their financial histories. Well, pay something per. So next time you don't collect too much, or if you collect, you secure it a little bit better, or you buy insurance for it, for your this kind of liability, so that the insurers will tell you exactly what to do because they do it for everyone and they'll know how to reduce the exposure and so forth. Or, again, a holy kind of a sacred provision of the digital era, Section 230 of the Communication Decency Act, that provides safe harbor for websites against harm that arises from content that is posted by their users. Why have such, these gatekeepers in every other area of the law? When we can't go after the bad guys, the wrongdoers, we go after gatekeepers. Vicarious liability, secondary liability, contributory negligence. That's what we do. Why not here? Especially for things that are harms that arise not directly from the content, but from design features. Why should roommates.com allow people to choose whether they want to, which race their roommates should be? It's a question. If we think that that leads to effects that are socially bad, then there could be liability for that design. Why the Snapchat or SpeedChat or whatever one of these allow drivers to post and brag at their speed that they are driving? So when you reach 100 miles an hour, you get, extra star or something like this. And indeed, courts sometimes find these websites liable, but there's no doctrine that is developed for what. Did you know Karan Lalla that graduated last year? So he wrote this great paper. It's published in a student note in the law review, in the Chicago Law Review. Developed this, I'm just borrowing it from him, this idea that you can override Section 230 by creating liability for what he calls content agnostic claims. These are all tools that we have in other contexts for liability directed at industrial pollution. We have the blueprint. It's a big project to adjust and adapt it to different kind of fuel, data, and different kind of manifestations of harms. But that's where we need to look at because we are trying to protect environments. So I'll just end by saying, I think everybody is concerned about it. And surveys show that people are concerned about their privacy. But they keep splashing their data everywhere, and we have this paradox. And I don't think there is a paradox. The only problem is that we didn't provide the survey respondents with the right vocabulary to articulate what it is they're worried about. I am worried too. I don't care if I accept all the cookie consents. Just stop asking me. But I am worried. I'm worried about something bigger than the fact that my privacy in some sense will be compromised. And so people are saying to us, we are worried and do something for our environment. And what we're giving them instead is a right to be forgotten, a right to consent, data self-determination, and a whole bombardment of cookie consents. Gotta stop doing that. Okay, I'll take questions now. And I will concede many points. I'm not going to attack you if you disagree with me. So even though I'm very passionate, as you saw. Yes?
I think for a lot of people, maybe a first step towards being willing to release certain privacy laws would be, maybe I'm not okay with my data being affiliated with me personally, but if you anonymize it and use it as training data, that's fine. And particularly, this is in the medical domain. But I'm just curious because your kind of points seem to be really with respect to things that do matter with the person and cannot be anonymized. If you think that sort of thing is ever useful, and if so, like where would it be?
I'm sure there is. Privacy is important. Privacy is vital. Data privacy is vital in many contexts. In the context of medical privacy, I'm worried about red states going after women or people that what they call accomplices that conduct, procedures that they think are now that they criminalize and follow them through all sorts of tracking thing. And I want there to be protections. But I think that by spreading privacy protection so broadly, we have dulled the difference between true core privacy concerns, where we need to build a strong protection around it, and everything else that is just pollution, that people don't care as much about. And it's hard to argue with the privacy people because they will always show me a case in which it is core privacy concern. And I'm not against that, but I'm trying to suggest that that should not be the blueprint for the entire regulation. It will not do much good for people to give them such strong privacy rights everywhere. It just bothers them that they need to constantly manage their data, the personal data policy. And it ultimately compromises the important protections we want to secure.
So the theme of your talk seemed to be that people tend to overvalue the cost or the value of like their personal data, and they undervalue like the public benefits that could be derived from it. And I'm just wondering what you think the solution or the future of like this problem is. Like obviously things like your book help convince you like, oh, maybe there's public value, but I'm just wondering what do you think will happen, like if it gets worse or gets better, what the states might do, et cetera.
So I don't know how to respond to that. I live in the world of basic ideas, right? The Chicago's ideas, right? I think that there has been a lot of influence to academic circles in the area of data privacy. This is where the engine of the EU laws. Every year there's a new EU. Now it's the Data Fairness Act. Last year it was the Digital Fairness for the Digital Markets Act, the Digital Services Act, the GDPR. Each one adds rules, and every time I go to Europe, I see the entire academic enterprise in the area that used to be called consumer protection is all busy working, following up with how to implement this and to make sure that people comply. I kind of would suggest, and when I go they invite me to this conference to give the counter, to think differently. And what happens in the culture of academia is that there is great agitation among most of the audience, especially senior people. I've had people stand up and telling the audience, don't listen to him, he is misleading you. It's people holding their hands like this. This is a very ideological, the life members of the guild are very ideological. But then there is the coffee break, and the young people come and talk to me. And that's where I feel, ideas can have purchase, can kind of infiltrate. So that's all I can say. Please.
In your experience, is data privacy bipartisan?
No, that's the reason why. Here's the paradox. Data privacy law has been immensely successful in one dimension, passing laws. Immensely failing in another dimension, advancing privacy. How do we explain that? So here's first, a rule of thumb. If you see that all parties support a rule, the rule probably doesn't have much effect. 10 years ago, I stood here in Chicago-based ideas and talked about a book that I then published called More Than You Wanted to Know, about the failure of mandated disclosure. Mandated disclosures in every area of the law always fail. They do nothing to solve the problem. But we looked at, I provide data. I showed evidence. When the Truth in Lending Act passed in Congress, that's protection, mandated disclosure in mortgages, everybody supported it, 97-1 in the Senate. And different rules, always like that, bipartisan support. Now we look at privacy laws, HIPAA, the Privacy Act, state privacy laws. They are almost, unless they provide a private right of action, where there is bipartisan. If there's no private right of action, there is bipartisan support. But these laws don't do much. So it is, and we can then see also why. Data privacy, everybody's okay with it. Progressives like it because it protects the people, their privacy. Libertarians like it because privacy is, liberty. Big big corporate interests like it because they'd rather do these laws than have serious regulation. They don't mind giving you cookie consents. And so that's why that's how it passes. Yes?
I liked, it changed my opinion a lot at the beginning, but when we get to the environmental law analogy, I love law. So one thing to secure is liability for exposure, not harm. Could you explain that a bit more? Because myself, I've got over $1,000 so far from these data breaches, including one was hundreds from an air ambulance company, and I never even been in a helicopter, so I feel like no one's ever asked me when they came to this money if you can harm. They're just your data's been stolen, here's $100, shut up. And I'm like, thank you. So it seems like that we have that regime right now. I'm missing something.
Okay, no, so what's happening here is we have a regime that sometimes there are lawsuits that manage to get some type of compensation, and if you're sophisticated enough, and you look very sophisticated based on just not your look, but the amount of money you managed to garnish, is that you clicked or did something to accept this. Money that doesn't just arrive a check. It arrives a little postcard and says there's been a day, you read it through, you understand if you understand, and only very few could, what they're really talking about, you go to some website, you click through some things, you get at the end of this Via Dolorosa, you get to the point where they'll send you the check. And check after check, you've gotten $1,000 or more. Most people don't get. Many times if there are sanctions that are by law, they have to do with a failure to notify you in time. States have notification laws, mandated disclosures, that let people know that there was breach. That's why you get those emails or these cards once in a while. They have to, but if they don't comply exactly, there's a lawsuit. Private lawsuit, class action, and for that there are also statutory damages, and that's partly what you get. Occasionally data spills try to use tort law, and mostly they fail on standing because there's no actual harm. All the new great standing cases in the last decade had to do with data spills, with data security breaches, and the court saying, is this a concrete harm or not? Even if they have standing, they can't show harm because you didn't realize it. How can you know that whatever it is, some fraud is due to the Target breach as opposed to the Yahoo breach, as opposed to the Social Security or Equifax? We have problem of uncertainty of causation. So it's very hard to recover. What I'm saying is, I don't want people to recover. Largely, they have insurance against it. You got $1,000 without suffering any harm. So there's no need to recover. What environmental law does is not compensate individuals. It's not private law. It protects an environment through fines that are collected. What's important to me is that the wrongdoers will pay, not that the victims will collect. It's also important, but let's first protect the environment and only later worry about find a way to also make individual victims able to recover. Maybe one more question? Yes.
Do you have an answer to your hypo that you posed earlier about the red states tracking movement into blue states, or any misuse by the government in general? Because it seems like the solutions that you pose would do a good job at kind of shutting down some of the concerns we have with regard to private companies, not securing their data or misusing the data. But I think one of the real concerns that people do have is the government.
Yes. Yes.
And do you have any what is your inkling about how we should respond to that concern?
So here's one thought. Right now we have very, very strong medical privacy laws. HIPAA is a super stiff law that limits a lot of, and you would say, okay, at least we get something good, because a woman who is going to have an abortion in a neighboring state will not be tracked by the police or finding it. Well, guess what? With all its might, HIPAA has an exception for law enforcement. So the one good thing that we could have had from it, we don't get. I want to reverse it. I want us to be Denmark. Denmark doesn't have medical privacy law. All your information from the day you're born are in a national registry, and all the hospitals and clinics can get all the charts and do statistical analysis. And I don't know, life in Denmark doesn't seem like particularly, destroyed as a result of that, but innovation is on steroids. In the US, because of our consent laws that supposedly protect this kind of situation that Martin here raised, red states and all that, we have such limits on innovation and medical innovation. If I had time, I would give you examples. It would kind of, you will be, it's jaw-dropping. And we don't get the one benefit that we want. So you're asking me, okay, you'll say, but that's not what I asked you. I asked you what would you do? And I say, I don't know. I mean, I'm not an expert on every individual sector. I'm an expert in nothing. I can look at the whole thing and say, this is what the picture looks to me. But if you want me to zoom in one particular area of activity, like medical practice, like policing, I will say, we need to build good guardrails that are focused on the particular high harms that we're worried about. Exactly how to do that? I know how to do it for mortgages. I know how to do it for other types of transactions because contracts is my field. I'm not a criminal lawyer, and I don't know how exactly to put handcuffs on law enforcement so that they will focus exactly on what they're supposed to and not go beyond that. But it can be done, and at least it needs to be tried because there's too much at stake if we don't. Thank you for your patience.